Namaste ji namaste. Hope you're doing well and keeping safe. So in the last 2 days, one order by the Supreme Court on sedition and one judgment, a split verdict by the Delhi High Court on striking down the exception in 375, that is a rape under the IPC that relates to marital rape specifically, has been delivered. So we are going to be discussing the judgment tomorrow. It's a 393 odd page judgment. I need to study it and then extract out all that the examiner can possibly ask us. Today we discuss the order that has been passed by the Supreme Court on sedition. So first and foremost, जो petition का नाम है SG Wombat versus Union of India, Wombat. So this is writ petition and an order has been passed. Since we are going to be talking about sedition, we need to know where it's placed in the IPC. So that's chapter 6, titled of offences against the state. Judiciary वालों के लिए standard chapter याद करनी है. कितने हैं? Amendment नहीं. Official title last is chapter 23, contains section 511 on attempt. Since we have spoken about chapter 6, we need to go to chapter 4, we need to go to chapter 5, we need to go to chapter 5a. Chapter 4, general exceptions, section 6 read with other sections. Basically everything in the IPC is subject to general exceptions. Chapter 5, abetment, 5a, criminal conspiracy, 6 of offences against the state where sedition is given under section 124a. It's been classified as an offence, and I think if I'm not mistaken, offence ki definition is section 40 of the IPC. Just look it up. And so we go into brief history. This petition was listed out on the 15th of July, then notice was issued very recently on the 27th of April. Koi ye aapke liye relevant nahi, I'm just building up a base for the discussion. The Solicitor General asked for 2 to 3 days time, and then 5 May it was asking more time. Actually the central government was flip-flopping on this position, and now the Supreme Court via its order has basically held the government by the neck, it can be said figuratively, and said ki you will stick to your position. Okay, ji. Now what is the position? So let's look at the affidavit that's been filed on record by the Union of India stating a few things. So they say that we know about the views expressed in the public domain by various jurists, academics, intellectuals and citizens in general. We also think that a law should exist for controlling the acts relating to destabilizing the government established by law, alright. But we know of the concerns and we acknowledge those concerns, that concerns are raised about its application and abuse for the purposes not intended by law. So this is a section that is as alleged frequently misused by the government to silence its critics. That is why, well, the petitioners are requesting the Supreme Court to hold it ultra vires to the Constitution. And ऐसा नहीं है कि ये पहली बार ये matter उठा. There are judgments to this. There is a law commission report on this. I'll extract out everything. So if you're serious about your exams, try to watch this lecture till the end. All right. So in the affidavit states that the PM is in favor of protection of civil liberties, and he says that one of India's strength is the diverse thought streams that beautifully flourish in our country. Expressly, that's a fundamental right under Part 3 of the Constitution, Article 19, Clause 1, Subclause A, subject to the reasonable restrictions, as in 19 Clause 2, the word reasonable introduced by the First Amendment, 1951, and there were specific grounds inserted in that amendment. Homework for you if you're serious about clearing your prelims. So UPSC, LLM Judiciary wale, all these are MCQs that can be asked. So PM is Azadi Ka Amrit Mahotsav ke andar, they want ki one of the aims of Azadi Ka Amrit Mahotsav can be to shed colonial baggage that has passed its utility. कि अब शायद ये 124A का time up हो गया है. They're not specifically talking about this, talking about laws in general, that there are certain sections under various acts that were primarily suited when Goras used to rule us. Now that's not anymore the case. So यहाँ पे there's a counter debate to that also, ki is sedition really a colonial era law, because most of our core laws, Contract Act, Evidence Act, IPC, all belong to that era first and foremost. And then this offense, this word was also considered by the Constituent Assembly, and perhaps they chose to keep it. Now that is a very interesting observation. It just may not be colonial era, but that's a counter debate reserved for a separate date. So यहाँ पे they have said, thanks to these reasons, the government, the central government, that they have decided to re-examine and reconsider the provision of section 124A of the Indian Penal Code, which can only be done before the competent forum. So they want to re-examine and reconsider, thanks to, well, we are for protection of civil liberties, we don't want this offense to be misused, we are all for freedom of speech and expression. India, one of India's diverse strengths is the diverse thought streams that flourish in the country, etc., etc. All right. Now, their request, the central government's request, is that this honorable court may not invest time in examining the validity of section 124A once again and be pleased to await the exercise of reconsideration to be undertaken by the government of India before an appropriate forum. वो कह रहे हैं जी आप क्यों टाइम खराब कर रहे हो अपना, आप एक दो बार इस पे टिप्पणी दे ही चुके हो, मतलब यहाँ पे लड़ाई क्यों लगा रखी है? लेजिस्लेचर है, वो अपने आप डिसाइड कर लेता, उसके बाद आप उस पर टिप्पणी दे देना या आप उस पर डिसीजन दे देना कि जी ये ठीक किया हमने या गलत किया. बट फर्स्ट गिव अस एन अपॉर्चुनिटी टू re-examine the validity of section 124A. All right. Now, this is pretty much, you can say, the ratio. Abhi judgment to nahi aayi, but you know, technically speaking, since this ratio, in view of the above, it is clear that Union of India agrees with the prima facie opinion expressed by this court that the rigors of section 124A of IPC is not in tune with the current social milieu and was intended for a time when this country was under the colonial regime. So Supreme Court prima facie thinks that 124A was primarily used to be a section that was specifically carved out to curb the independence movement and against freedom fighters. As I've said, there's a counter debate to this that's reserved for another day. Therefore, we expect that till the re-examination of the provision is complete, it will be appropriate not to continue the usage of aforesaid provision. तो इसको standby में डाल दो, लैपटॉप का ढक्कन बंद कर दो without shutting it down. So the laptop is in standby. अब कौन सा लैपटॉप? 124A का लैपटॉप. तो therefore they issued guidelines. Guidelines में क्या क्या दिया कि जी state and central governments will refrain from registering any FIR. इसमें पूरा एक MCQ बन जाएगा. What is the guidelines issued by the Supreme Court? So option A, will refrain from registering any FIR if any fresh case is registered under section 124A of the IPC. The affected parties are at liberty to approach the concerned courts for appropriate reliefs. All pending trial, appeals and proceedings with respect to the charge framed under section 124A IPC be kept in abeyance. Now when I've read this, all pending trial, appeals, what if someone's been convicted and they have appealed it? So that's pretty much a lacuna there. But all pending trials, appeals and proceedings, they have said with respect to the charge framed under 124A, charge कहाँ frame होगा? Charge sheet में जाए CRPC में, be kept in abeyance, that is suspend कर दो. Then more MCQs that can be extracted. Now this was pretty much one MCQ that usually is CLAT PG level, alright. So Kedarnath Singh versus State of Bihar, 124A की section की validity has already been upheld, but has it ever been held to be ultra vires by any high court? Yes, ultra vires, that is, they wanted to strike it down. This was under Tara Singh Gopichand versus State. This was a Punjab High Court ki judgment in which they said 124A को हटाओ, it is ultra vires the constitution. तो दो MCQ basically आपके judgments पे बन गए. And Kedarnath Singh versus State of Bihar was pretty much a hot MCQ last year as well in 2021 when Vinod Dua versus Union of India के अंदर FIRs were quashed. So this case was primarily referred to. So they said कि जी ऐसा है sedition के अंदर आपकी जो वो hatred, contempt, disaffection वो सब सही है, but till the time that your speech or any words they incite public disorder, it will not amount to sedition, and criticism of government is not sedition. So Kedarnath Singh versus State of Bihar mein this was amply clear. This was a pretty solid judgment, all right. And last year की judgment का नाम है Vinod Dua versus Union of India, in which FIRs were quashed against Vinod Dua and because he was criticizing the government and specifically PM Modi's handling of COVID-19 situation. And that judgment was referred to that this is not inciting public disorder, so this cannot be sedition. So, well, basically charges were dropped. Then UK mein the Sedition Law was repealed in 2009. US made it still a federal felony or an offence. Australia mein the offence has been done away with. Singapore also has said tata bye bye to this offence. But the trouble is अगर हम IPC से हटा भी देते हैं, so under the unlawful ये आपके Activities Prevention Act 1967, उसके अंदर अगर आप unlawful activity की definition देखें, it is pretty much sedition only. तो वहाँ पे छोड़ देंगे तो यहाँ से पकड़ लेगा. तो this is also a point to be noted, my lord, in relation to an individual or association means any action taken by such individual by committing an act of words either spoken or written or by signs or visible representation which is intended. It is pretty much the same thing. It uses very similar terminology. So one has to be careful. If IPC में से जाएगा, so this provision may need to be considered because it's pretty much अगर doctrine of pith and substance आप use करें, maybe it is sedition. अच्छा, 42nd Law Commission ने कहा था that please reconstitute, that is rewrite section 124A so that it can be the misuse can be avoided, and they also recommended insertion of section 124B. This was never done, by the way, by the legislature, never implemented. Law Commission की reports काफी कुछ बोलती हैं, but as always is the case by the legislature, they just don't implement quite a lot of stuff. So 124B is insult to the constitution. So they said that make it an offense to that if insult to the constitution is done, flag, emblem or any national symbol, well then it's an offense, and this would have cancel out a lot of controversy, a lot of case laws that happened later. So that pretty much it is the order, and that pretty much it is all the relevant MCQs that can be pulled out from this order of the Supreme Court. Tomorrow we discuss the judgment on marital rape by the Delhi High Court. Dono judges ke decision ko we'll analyze. It will be a lengthy lecture, but hope to see you on that one. Wishing you all the very best for your examinations. Take care. Bye.